Good morning, everyone. I am David Bernstein. I am the Executive Director of the Liberty and Law Center here at the Scalia Law School and a professor here for many years. I wanted to welcome all of our speakers and commentators and also all of our guests who are here for this very interesting panel. I also wanted to welcome our co-sponsors, the Institute for Justice. I will let my colleague JoAnn Koob tell you about our center momentarily, but I want to say a word about IJ. My ties to the Institute for Justice go back to when I was in law school, and I was a clerk or intern really for Clint Bolick, who was a co-founder of the Institute, who was then at the Landmark Legal Foundation. And I remember him excitedly telling me how he and Chip had just gotten a grant to start the Institute for Justice. Then coincidentally, when I was a young lawyer in DC, the Institute for Justice had offices in the same building as my building. And when I would sometimes get bored or frustrated with my legal work, I would just sort of mosey on down the elevators and hang out with Chip and Clint and Scott Bolick, who at the time were the only employees, or only lawyers, at least employees of the Institute. And in the ensuing 34 years, I've watched IJ grow from that relatively humble start into the litigation powerhouse and public relations powerhouse it is today. And I think no organization has done more to advance the principles of individual liberty and constitutional rights in that period than IJ has. So thank you, IJ, for all you do, and thank you for co-sponsoring this conference with us. And with that, let me turn it over to my colleague, JoAnn Koob.
Thank you, David. I work with David. I'm the director of the Liberty and Law Center. We started it approximately 8 years ago now, and I also teach at Scalia Law School. We're really happy to have you all here, and I want to welcome you as well as thank you all for coming, and give a special thanks to IJ, Anthony Sanders and his team for co-sponsoring this event with us. They have really worked tirelessly to make everything happen and go very smoothly. But for those who don't know about the Liberty and Law Center, we are dedicated to individual liberty, freedom of speech, and the rule of law. We have a number of programs to advance those, including a civil discourse program where we train law students and other students as well to engage in civil discourse and talk through their differences and learn how to talk with people who they strongly disagree with about important issues of the day, a sort of lost art that we are trying to revive. We have a free speech legal clinic where law students at Scalia Law work on First Amendment cases that are in the courtroom under supervision and get experience litigating, and we like to think instill them with a passion for defending individual liberty when they graduate. We have another free speech program called Voices for Liberty, and through that we are exploring the relationship of civil rights and social progress and freedom of speech, and how has freedom of speech informed civil rights throughout our history. And that is a multifaceted program, so through it we've produced scholarship, hosted academic events, and we also have a nationwide campus speakers bureau. At this point, the initiative is about 4 years old, and we've been to 125 campuses and reached over 6,000 students. And then finally, we do a lot of research and events like this one, where we have, put out calls for papers, have people write papers, present them publicly at events. And today is a great example of that. I think that we have a really great lineup coming, and I will actually turn it over to Anthony Sanders to tell you about that lineup. He is the director of the Institute for Justice's Center for Judicial Engagement. Anthony.
Well, hello, good morning, and welcome. Thank you very much for those kind words, JoAnn and David, some of which are deserved by myself and my colleagues. This is the third time we have partnered, to my memory, there might be more than that actually, but before I was so involved, but the third time we've partnered with the Liberty and Law Center for a conference like this. Every time it is nothing but a joy, and so I really want to thank everyone at Scalia Law and the Center who has been involved with this, especially JoAnn, David, and Farida. Thank you for partnering with us once again and letting us into your wonderful facility and your wonderful networks and your wonderful students, some of whom I know are going to be here today. So I'm going to have a few more thank yous. Then we will have a little bit of a roadmap, as us lawyers like to say, about the rest of the day. And then I will introduce our keynote speaker. So in addition to the center partnering with us, the Liberty and Law Center, we are overjoyed that we are partnering with the Georgetown Journal of Law and Public Policy, which will be publishing the papers that you're going to be hearing about later today. It was a tremendous acquisition to putting this all together that quite recently we were able to partner with them, and so we're so overjoyed that we can have a symposium issue of their journal next year be the papers that you're going to be hearing about today. Also, thank you to so many people I work with at the Institute for Justice. We definitely don't have time to name them all, but there's all kinds of people behind the scenes in publicity, in design, in all kinds of aspects that make an event like this come together. You will hear from many of my colleagues later today on various panels, and so look forward to hearing from them, and thank you to them as well as everyone else who has joined us today. I do want to especially thank three people. One is Erin Norgel, who is on our production team, and she designed this wonderful logo for the conference with the quills and the other. We'll get to why the other is both underlined and in italics in a little bit. Also, my assistant director at the center, John Wrench, who has put together the last event of the day, which is the mock argument, which I'm really looking forward to. And most importantly, our events director, Kate Ritterpusch. If it had not been for Kate, we wouldn't have anything like a conference, let alone as great as it's come together. So a special thanks to her and thanks to everybody else. So a couple years ago, we at IJ were thinking, well, everyone's going to be doing this America 250 thing in a couple years, in 2026. I mean, you just kind of look at the dates, right? And that jumps out at you, oh, that's going to be 250. And so we knew that a lot of organizations would want to mark this, of course. And they'd either be doing it as about 250 years of America, which is good, or 250 years after the Declaration of Independence, which is also good. And we do not in any way mean with this event and how it's titled to cast any shade on the Declaration of Independence. We are very pro-Declaration of Independence and incredibly important. I would say it's the most important declaration of 1776 even. But the thing is, there were other declarations in 1776. There was a lot of other things going on in that fateful year. And we thought, what is important to us at IJ about that that's, not just those other two things that everyone's going to be doing? And what jumped out at us was the declarations of rights that you'll be hearing about later today and their later ramifications. So, as you know, we at IJ, most of what we do is litigation. We're litigating in state and federal court all over the country. Not all the time, but a lot, I would say predominantly. We are litigating about the Federal Bill of Rights, as it came to be called, or state bills or declarations of rights, and them being a constitutional document, enforceable in court. What does that mean? Where did that come from? How do we discuss that in a historical context? How do we bring meaning to those documents? These are all questions that began arising in 1776. And so we thought that would be the perfect vehicle for us to celebrate America at 250. And so that's the genesis of this conference. Now, along the way, we had a competitive call for papers. And we had many applicants, but especially the 6 that we chose. We thought they're going to be fascinating topics. And so you will hear from those today. We've tried to pair them kind of as best they can, but all 6 are kind of their own take on this area. Some are going to be digging into exactly what happened in 1776. Some are going to be the ramifications after that. And some are going to even bring us up to the present. So we're going to kind of have all angles of that history. And then we're going to have the event at the end of the day that I'll leave for my colleague John Wrench to explain to you later. But basically it's how did these pieces of paper come to be enforceable in court, which is not something many people were worried about in 1776. What were they worried about? They were worried about British cannons and warships. And so that brings us to our keynote speaker. So before we had our call for papers, we knew we needed something that would make people realize this is going to be a big deal. And so, of course, I thought about something that happened 250 years ago when we were at war with the British. We need someone who was British. And I don't mean myself. Because although it doesn't sound like it, I actually am a subject of His Majesty and of the British Empire, or as we call it today, the UK. But we needed someone with a little bit more expertise than myself and also a better accent. And so we reached out to Dr. Nicholas Cole. Now, for those of you who don't know, Dr. Cole knows more about American state constitutions than basically any American. And he's not American at all, although I think we should think of as an honorary patriot. He is a graduate many times over of the University of Oxford, and that is where he is now at Pembroke College. He is a senior research fellow at Pembroke College. He has an absolutely extensive knowledge of American constitutionalism, both 1787 and all that, and the creation of the federal constitution, but also state constitutions. If you want to know what the archives look like for the 1895 Utah Constitutional Convention, he's probably the first person you should turn to, along with basically every other constitutional convention in American history. He has put that knowledge to service, and if you ever want to do some research on American state constitutional creation, and also actually the federal constitution, and even constitutions in other countries, the India Constitution, the Irish Constitution, you should check out his center. So he has been running for over 10 years a project called Quill, which is, I'm going to butcher it in describing it. Nicholas can correct me in a moment. But it is an online database of how constitutions come together. So not just, the words of the First Amendment and what courts have said about it, but how it came together. What was the parliamentary process in these chambers where someone would have a motion for these words, and then someone would have an amendment to it, and then there would be a debate, and then it would go to this committee, and then it would go to this other committee. That is spelled out in the Quill project in their database. So again, if you ever do research on this, whether as a research project or if you're in litigation and you want to know what the background was to the specific provision in this one constitution, then you should check out the people at Quill. So we thought that there can be no better sign of reconciliation between our two nations after 250 years. I know we've fought a couple wars together and all that, but maybe there's a little bit more healing that can be done than to bring on this fellow from Oxford to tell us a thing or two about our own constitutional history, both declarations of independence in 1776 and declarations of rights. So let me welcome Dr. Nicholas Cole.
Thank you. I wonder if we could switch over to my slides. Where are the AV people? Well, just while we're waiting for that to happen, I suppose the first thing to say is we're sorry. It all got a bit heated. We apologize. We know we were wrong. Anthony, thank you very much for that introduction, which I can't possibly live up to. Thank you to everyone who's made this possible. And thank you especially for doing this conference. I was also at a planning meeting about 18 months ago for a cultural program around America's independence, this time with British and European organizers who were thinking, well, what would happen in Britain and Europe for America's 250? And the conversation, I'm sorry to say, went very much as you would expect. People started to say, well, should we reflect on how America hasn't maybe always lived up to some of its... And I remember getting quite cross with my colleagues in that meeting and saying, you know, that's been done before. That's been done by the Americans themselves. That was being done within 10 years of the Declaration of Independence. There's nothing new in that. Could we maybe celebrate America's tradition of self-government? I'm not sure I won that argument there, but what I want to talk about this morning is America's tradition of self-government. We have a very sanitized view of declaring independence. There's this lovely 1817 picture that portrays a scene that didn't happen, where in this very orderly way, the Declaration of Independence is presented for signing, and people are painted there who definitely weren't there because they were ill, or they hadn't been elected yet, or they were off doing other business. So I'm going to talk a little bit about the process of independence this morning, and that's important when we think about the status of the Bills of Rights that I know other people are going to talk about later. And I don't want to tread on their toes, so I'm going to set the scene and describe the process of declaring independence. As Anthony said, I think the reason I got asked, other than that having a Brit say, I'm sorry, repeatedly, which I will do throughout this morning, is I've been running this project for 10 years, which is an effort to really think about how America's constitutions at state and federal level get drafted and to give proper access to the records. And if you want to see all of that, please do check it out online. I'm not going to dwell too much on the mechanics of that this morning because we have other business. You might ask why somebody with my accent is interested in American history at all. And for me, it has always been about this, which I read when I was an undergraduate for the first time. It's frequently been remarked, says Hamilton, that it seems to have been reserved to the people of America by their conduct and example to decide that question whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend on accident and force. And I don't think what he meant was 55 people at one constitutional convention. I don't think what he meant, for that matter, was anything nearly so limited. And I'll explain over the rest of the next half an hour what I mean by that, I hope. But on the other hand, we have this. This is Thomas Jefferson's self-designed memorial to himself. And Thomas Jefferson wants to be remembered as the author of the Declaration of Independence, of the Statute of Virginia for Religious Freedom, and father of the University of Virginia. He misses famously being president off this list. And Jefferson wanted to be remembered as the person who had written the Declaration of Independence. So, thank you. So John Adams and Benjamin Rush in 1811, also reflecting on the anniversary of independence, have have this wonderful little correspondence with each other. They have this wonderful little correspondence with each other, and they're in a very pessimistic kind of mood. John Adams is reflecting to Rush that really the Whigs, as he calls his sort of party, are not getting the attention they deserve. And he says, we haven't really captured the theatre of politics in the way that some of our political opponents have captured it. And he says Jefferson ran away with all of the stage effect of the Declaration of Independence. It's a rather sort of bitter comment on Jefferson's self-promotion. And they reflect on what it was like to sign the Declaration of Independence. And they write this exchange on their speeches. Adams mourning that it's become too much a military celebration in American memory, that actually he wished that there had been more thought given to all of those who worked for independence. And Rush recalling a famous moment when they were signing the Declaration of Independence and reflecting that they might all be hanged for doing it, and making some rather gallows-humorous jokes about who would die first, because who was heavier than other people. And that's very much the sort of gallows spirit in which Adams and Rush remember this signing of the Declaration of Independence. And John Adams remembers, and of course he's got no polling, he doesn't know, but he says famously, fully a third of people in America, and maybe more than half of New York, were against independence. And so he has this metaphor, both at the time and later, about 13 clocks striking at once. Now, I don't know how many of you have mechanical clocks in your home, and for the students in the audience, this used to be how we told the time. Before we had iPhones, we had this winding mechanism, and it would chime. My parents used to love mechanical clocks, and getting even two of them in the same house to strike within even a minute of each other is impossible. And John Adams says, both in 1776 and again in 1818 later, how impossible it seemed to declare independence. Because it wasn't the case that simply a declaration in Congress, even one written by Thomas Jefferson, was going to be enough to achieve independence for America. I want to contrast as well the British proclamations. And again, we're sorry. But one has to think of the Declaration of Independence itself and the state declarations in the context of what the British were saying themselves. One of the things that makes it much, much easier to declare independence is that the British monarch told you all that you all were already rebels, which is enormously helpful if you're arranging a revolution, and threatened violence against anybody who did not turn in their neighbors to be arrested for stirring up rebellion. Or what about in Boston, this general pardon, except if you were Sam Adams, who was explicitly exempted, or John Hancock, who was explicitly exempted. And these are documents designed to be pinned up, they're designed to be reprinted in newspapers, they're designed to be widely disseminated. And that's really why the Declaration of Independence looks as it does. This is a document designed to be short, designed to be printed, designed to be reprinted by newspapers. It was reset hundreds and hundreds of times by different newspaper editors. It's short enough to go on the front page of newspapers at the time, even with space for advertising, which is fantastic. And so it was. But notice what's not here in the first printing, the first authorized printing, that July printing of the Declaration. Let me put up the January 1777 printing when the war is not going well, and we're sorry. And you can see there is a word here that's been able to be inserted. Sorry, I should have said the New York delegation had to abstain here. And so if you look at the 1777 printing, you can see that the word unanimous can at last be added, because in July, it wasn't only the case that individual members of Congress refused to sign and either continued to serve in Congress or resigned, but it was the case that a whole state delegation had to abstain, so they couldn't print the word unanimous. And it wasn't until the second authorized printing that they were able to say, this is the unanimous declaration of the states. But that was important. So I'm interested in these processes where groups of people, not individuals, agree on text. And the Declaration of Independence is no exception, but the work I've done has mostly been around constitutions. And if we just take the federal constitution and we think of the work of that convention, when we usually teach it, we gloss over this for students. We present it as the work of a few geniuses. We perhaps present high school kids with the New Jersey plan and the Virginia plan, and we give them 45 minutes and say, do you think you can split the difference between those two things? And we gloss over the fact that if a bright high school class of 16-year-olds can take 45 minutes to split the difference between the Virginia plan and the New Jersey plan, then what was the convention doing for 3 months? So if you map out that kind of decision-making, this is what we sort of do at the Quill project, what you discover is that the convention considered 88 separate pieces of paper at different points in its work, and considered around 1,000 amendments for 2,500 words of text, which is quite an extraordinary level of detail. And this is part of a tradition of collective drafting of text that continues long after the revolution into state constitution writing. So, between 1776 and today, America has written for itself 235 new constitutional texts at state level. And it's quite extraordinary what little attention until the last 10 years all of this constitution writing, all of this collective drafting has really received. And I'm very grateful to many people in this room for the work that they have done to really turn attention back to these very important state texts. And very quickly, right from the beginning, although the states experimented very early on with other processes, convention processes where people would sit in a room for a month, 2 months, average of 3 months, maybe more than a year to write a state constitutional text, they became the norm. The records of these are extraordinary, they're exhaustive. This is just one group of students in South Carolina that I've been working with, going into archives and looking at these texts. But it's part of a long tradition of collective decision-making in America that is really important and that is captured in all of these manuals for how to do it, which are very popular not only with legislative assemblies at state level, but other organizations as well. There's this huge tradition of collective drafting of text in America. It's a tradition that we're beginning to lose sight of, I fear, but it's really, really important for America's constitutional history, that we recover that tradition. It's also really important that we remember that this is how America has always reached compromise. You know, when people are calling more and more in politics for compromise, well, the tradition within which America has found its best compromises have been these formal processes. And it's also important for independence. So I fell out of that meeting 18 months ago and I thought, well, what is my project going to do for the 250? What can be our contribution? So we put a set of digital collections online. One thing we thought we'd sort out was who was actually present at Congress at different moments. Turned out not to have been work that had been properly done before. So that's one thing that we've done, because people are joining and leaving all the time to go off and organize rebellion, patriotism, in different places. I'm sorry. And then charting the resolutions of Congress for the previous 18 months that captured either declarations of rights or grievances that could feed into the declaration's text. So we've filleted the records of Congress to get to those. And then we wanted to revisit the drafting process for the declaration itself, and think about, well, what manuscripts did we have, and was there any merit in going back and looking at them? So we've gone back, we've traced, and I think now conclusively worked out the sequence in which different manuscripts must have been produced and who had what when. And then lastly, trying to provide more insight into the many local and colonial or state declarations of rights or independence that were issued in 1776. So let me give you just an example. So this is from South Carolina. And you can see the drafting style changes quite quickly after 1776, but this is still part of an older tradition of drafting that looks much more like a colonial charter than a modern constitution for America. Huge whereas clause, listing a load of grievances, and again, we're sorry, they were right, I'm sure. Very quickly after this, there's going to develop a modern American style, but this looks much more like a colonial charter. Now, we're not the first people to look at all of this. Many people will be familiar with Pauline Myers' book, American Scripture, and she drew very heavily on the work of a 19th century scholar who collated together a collection of records and state papers and debates and letters in 6 volumes that chart all of these local declarations. And what we've done is put many of them online in a very accessible and searchable form so that you can go and see them. We started with the documents that Meyer listed in her annexes to later editions and then worked out from there. So you might then ask the question, well, what are the vehicles in 1776 for declaring rights or for declaring independence? We're familiar with town meetings in Massachusetts. What about the rest of America? What do you do in the rest of America to declare independence? Here's a town meeting, and you can see this very formal process with a secretary there to take the minutes. The question being put, if Congress declares independence, will we support it with our lives? Passed in the affirmative unanimously. So that's a sort of conditional permission for Congress to declare independence, isn't it? But what do you do somewhere else? Well, if you're in South Carolina, you don't have town meetings, but maybe you turn up for grand jury duty one day, and the Chief Justice would read out to you an 8-page treatise on everything the British had done wrong, and why that meant that the British Constitution was no longer valid, and that actually the colony was now in a state of nature and needed to organize its own government. And so that's what happened. In May 1776, a grand jury turned up, and they expected their oath to be administered to be a grand jury, and instead they got read an 8-page treatise on political theory and legal theory, explaining to them that they were a free people, and that the British had done a number of really terrible things under color of authority, which is always that wonderfully sarcastic word. And in particular, things like the Quebec Act were awful, and that they as jurymen really needed to take note of all of this. And they needed to take note as well of the constitutional theory of the Chief Justice that said that if government became too oppressive, it was no longer, government government at all. And for that, he relied on the Glorious Revolution and on William Blackstone, and so on. Then he issued the oath and said, by the way, you've also got to serve as jurors. We've got their reply, by the way, which is this. The jurors' reply said, yeah, the roads are pretty bad. And again, we're sorry. What about in Rhode Island in May 1776? And again, this is before independence has been declared by Congress. But Rhode Island is worrying about the administering of oaths to officers. You know, what are we going to do if everybody's swearing loyalty to the king, but we're in the middle of a dispute? So they pass an act saying, well, we repeal the oaths that mention the king, and now we're going to have our own oaths. Again, before July. But it doesn't have to be these formal bodies. So another place you can meet are militia units, associators. So here's a lovely example from Philadelphia where a militia unit meets and the officers say, well, the British are being pretty terrible and there's important work to be done. And then in a detail that I absolutely love, the privates have their own committee meeting without the officers. And they move and unanimously agree to a resolution that they will support independence. And you see another militia unit here. I've just put this up just to sort of emphasize this is not a sort of lone take. And so that feeds into what's happening then in the state constitutions, because the early state constitutions also need a declaration of authority. And so you see this language in Virginia in June, again, predating the Declaration of Independence, with a list of grievances that is going to look terribly familiar, including grievances that Jefferson will try and put into the Declaration of Independence and that Congress will strike out during drafting concerning slavery. And they say, as a consequence of these grievances, drawing on this same legal theory that if government behaves poorly, it is no government at all, as a result of those grievances, the Constitution of Virginia is established. And you see a similar declaration in Maryland. Now, what's the point of all of that? Why emphasize all of these local declarations? Is this just people jumping on a bandwagon? Are these just the ephemera of revolution? I think they are more important than that. When in the summer of 1776, having read the Declaration of Independence, Lord Howe goes to meet John Adams and others from Congress, they are able to tell the British this Declaration of Independence was unanimous. By that point, although they haven't reprinted a declaration with the word unanimous. New Yorkers signed on. This declaration was unanimous, and we're not going back on it. And even in 1781, when there are efforts to organize a peace conference in Europe, and John Adams and Franklin are worried about this, and worried, as they write to each other, that the British might try and break away European powers, get them to declare neutrality and so on. It was an enormous help and comfort that it wasn't only the Declaration of Independence that had been agreed upon by groups of people. The Declaration of Independence was a capstone and also a trigger for state and local declarations of independence and rights. And so the American ambassadors in Europe were able to, with confidence, say that there wasn't a state in the Union that was going to renege on independence, even though the British wanted to start trying to negotiate individually with individual colonies. And I think if there had just been the Congressional Declaration, and the British had been able to go to the members of that Congress and say, well, we don't recognize your legal authority anyway, and who are you to speak for all of America? It would have been much harder for those individuals to hold the line that they did, that they really were drawing on these local declarations of rights and local declarations of independence. In other words, this tradition of collective authorship of text that, yes, is captured in the Constitutional Convention, but which is also captured in all of these local areas, is also captured in all of these local efforts to declare independence, is captured in committees of privates in militias passing resolutions in a very formal style. That tradition is really, really important as a basis for America's government. And then the states are able to move forward on that basis. So South Carolina is just an indicative example. So after that sort of grand jury, here's this charge. The legislature passed tentatively a constitution and another tentative constitution. I put this one up because it's a very unusual state constitution because it's not issued collectively. This is a rare example of a text being issued in the name of the governor. And again, it's a tentative wartime measure, but it stands out to me as a text that does not draw for its authority on a collective action so much as the authority of a single person, which is incredibly unusual because all of these other texts drew for their authority principally on the fact that groups of people had drafted them. In fact, if America had known in 1776 that Thomas Jefferson had written a document about independence, what standing would it have had? The standing of that text rested on the fact that it drew on language that had already been debated in Congress, that had been debated in localities, that had been recommended by state legislatures, and that had been passed to Congress. And so, states, the state constitutional history takes a while to settle down. It's not until 1790 that South Carolina decides it's going to have a bicameral legislature. And states continue to redraft their constitutional texts for the next 250 years in different ways, although the tradition of conventions has been in abeyance for a while. Well, why write all of that? Why spend all of that time writing constitutional texts? Yes, so that they can be argued about in court. That's very, very important. But they are also exercises in expressing commonly shared principles, commonly shared philosophies, and gaining assent to those philosophies. And so, what then do we make of Jefferson's efforts to say, no, I was the author of the Declaration of Independence? And of course he was. And of course the concise text that is so quotable and more quotable than anything else in this period is, of course, the work of Jefferson, but he is drawing upon, even though he tries to persuade people that he should be remembered as the author of it, he's drawing on all of these other texts, which is why texts written months before the Declaration of Independence look so familiar when you go to read them. And it's on that basis, and not just arrogance, that he is able to say to people the Declaration of Independence was not novel. It was a text that drew upon the common sense of America at the time, and that was his task. His task was to synthesize the declarations that had come before and to capture the mood of localities as well as the mood of Congress. And so that's what I think Adams is talking about when he talks about making 13 clocks strike at once. It's this process of getting a whole continent to sign on to a set of values, a set of grievances, a set of rights that they believe have been violated, and getting assent to that, not only in Congress, but across America. Not only in formal settings, but in lots of other bodies as well. That, for me, is what we should be celebrating in the 250th. That, for me, is America's tradition of self-government. That, for me, is America's tradition of showing the world that you can have good governance through reflection and choice, and not accident and force. And so I'm very grateful to the organizers of this conference for being, I think, the place where that is going to be on show. And I really look forward to the papers. Thank you very much.
Questions for Dr. Cole. So if you line up at our...
Goodness. What if nobody moves?
What you have to say. And I forgot to mention earlier, the papers that are being are all available on the conference website. You've probably seen, but if not, Google other declarations 1776. I want to emphasize the papers are drafts, so about all that, because then the draft will be improved, of course, by the senior scholars we have commentating on them, and then questions. So, any questions right now?
Yes.
In these meetings where many different issues were discussed, how would any dissenters have been treated? And was the secret ballot used if measures were voted on?
Nope, there's no secret ballot. The secret ballot is a later invention. In fact, there won't be a secret ballot for a long time. George Washington, when he was being elected to colonial office, used to have a word with the returning officer and get his voters to vote first, and had a barrel of beer for them. I think there was a sense that you should stand by your vote if you were voting. In different localities, it was more or less dangerous to dissent. And in different places, it was more or less dangerous to dissent. So obviously, in very radical areas with very active committees of safety, sure, dissent is not tolerated. And many of these declarations say they're unanimous. So you have to think the people turning up are the people who are prepared to vote for them. But don't forget, John Dickinson not only didn't vote for independence, he didn't sign the declaration when given a chance later. And, even Congress permitted dissent. There are many people in Congress who either abstain, don't sign. There are motions to amend resolutions calling for independence. So there are spaces for dissent as well as for agreement. But I think it's a good challenge to say, yeah, absolutely. how easy was it to dissent? And I think the honest answer is it really depended where you were and what the sort of local mood was. I think that's a really fair challenge.
I think my question is a natural follow-on, which is were there any states or localities where there was a bigger debate or any particular issues over which people were really divided?
Yeah, because there are resolutions in favor of the British as well. And not all of the things that individual localities want to talk about would be acceptable at Congress. So in the localities, for example, there is a lot of angst about tolerance for Catholics in Quebec. And that is a feature again and again across America of declarations of what the British have done wrong. You know, one of the linchpins in some places of the sort of case that Britain was no longer a legitimate government was the Quebec Act. Well, that's not going to fly in Congress. So there is disagreement as to exactly the nature of the grievances. And you can think of the grievances in the Declaration almost as a subset of a broader overlapping set of grievances articulated in different places, because there is disagreement about what it is exactly that the British have done wrong. But restraints on trade are everywhere attacked. Claims that the British can legislate in all cases whatever are everywhere attacked. The threat of removing people to trial in different places are everywhere attacked. So there are commonalities as well, but then there are things that will only play in some places and not others.
Thank you.
Am I? Okay. My question's about North Carolina specifically. So can you talk a little bit about whether that was a unique kind of way of promulgating the Constitution there, or whether, my understanding is it was slightly different than other states where there was a formal constitutional convention. So how does what you said today kind of bear on that?
So several state legislatures have to just decide that they're going to pass a resolution for themselves, that they are the valid form of government, which is what South Carolina's legislature does. And Virginia's legislature does that. And so it's not utterly unusual. I think there's a turning point in 1779 in Massachusetts when the legislature does this and the voters reject it. So the legislature says, yeah, we've written a constitution for ourselves, and the voters say you can't do that. You can't write a constitution for yourself, and insist on having a constitutional convention. And remember, it's still wartime. This is before the war has ended, but voters in Massachusetts are feeling confident enough to say to the legislature, we absolutely insist that the ordinary legislature is not going to be in charge of its own authority, which is a real turning point. But up until that moment, pragmatically, legislatures had to issue declarations that they were the legitimate form of government. There wasn't always time to organize a constitutional convention. That's why in South Carolina, the initial constitution has a time limit on it. So it says this is only going to be valid for, I think, 9 months originally. And then they have to issue another emergency constitution, and it's not until 1790 that they get a proper convention process. But no, so there is pragmatically a bit of variation, but it is settling down towards, very quickly, a convention process as the legitimate source of authority.
Morning. Thank you for the very interesting talk. I was wondering if you can offer any insights on what sort of shared educational background, if any, that these little mini conventions and mini delegations and meetings were relying on.
So we've got syllabuses for colleges and so on. And when I was much younger, I worked on sort of classical education in America. I don't know how many professors are in the room, and I don't know how many professors think that the knowledge of their graduating class is accurately captured by the syllabus that they issue. We know that John Adams did not read his first year reading because he feels so guilty about it that he writes at length about not having done it in his diary after he graduates. And actually, some of his earliest political essays are written because he sets up a book club with people who also hadn't read Homer, and they agree to read Homer together and fine each other if they don't attend. But then rapidly, Adams's attention moves to other matters, and when we get some of his earliest political writing. So I think we can exaggerate the extent to which there is a kind of shared educational background in the 18th century that doesn't pertain in the 21st century. I think the general background level of knowledge that we assume other citizens have now is a pretty safe. I just don't think human nature changes so much. I think students have always been given ambitious syllabuses, and they have always read some of them. And that's true in the 18th century. Of course, the curriculum is narrower, but it is beginning to broaden, and science is very important and so on, and people are specializing. So if what's behind your question is a thought, well, was there just a shared liberal education? And do we lack that now? I would say there was more of an ambition for a shared liberal education and more agreement that that was a virtuous and good thing. But whether any individual person had read any individual text because it was required reading at university, probably not.
Thank you for coming out here. I wanted to ask more about that South Carolina grand jury procedure.
Yep.
Could you just elaborate on exactly what was going on there? Were they indicting the crown in some manner, or was it just we put these charges and are just going to talk about it?
They put the charges, and then we've got the grand jury's reply. And I think it goes to a point that Anthony made just in passing in his opening remarks. Not everything has to be something you can litigate in court. Sometimes it's just important that a thing has been done and published. And I think the important thing in that case, the courthouse remains very important in South Carolina, in local politics even now, but certainly was then, where government was really organized. And so to have the Chief Justice present a charge to the grand jury, have it printed widely, and have the jury's reply printed, that is an important thing in itself, because that is the state saying there are some constitutional principles that we need to work through. But I don't think it's the case that you can then sort of start, in some mechanical way relying on it. I think that really is just the extent. But it's also important that it's not a few individuals or even just the state legislature saying we're going to be independent now. There have to be other forums for people to assent. And so what's happening, I suppose, if you want to put it like this, is a performative exercise in some kind of assent that is outside the legislature as well.
Thanks, Professor, for your comments today. One comment and then a question. My comment is, in discussing state constitutions, if you haven't had a chance to take a look at the 1857 drafting of the Minnesota Constitution, we had two constitutions, a Republican and a Democratic Constitution, and they disliked each other so much they met in separate rooms and only adopted a final single version of the Constitution because basically the Congress of the United States told them, if you guys can't get together and get on one document, we're not interested in you.
There is some poor editor in Oxford who is working on that right now, and we expect to be publishing that in a couple of months. So
I'll be very interested in following up with you on that. But I do have a question, and that is, I'm wondering if, sort of back in the home country, so to speak, in your home country, as all of this ferment is going on, and people are, they're meeting and offering declarations and writing letters about the terrible things the king is doing. I mean, do those events draw any from the English experience? I mean, would you expect to see that kind of thing happening in England in that time? Is this all completely surprising to the leaders of England? How do they react to all of this? Does it look atypical to them?
I think it's typical in this way. So the parliamentary style of debate on which Americans are drawing is very British and goes back to 17th century manuals of how to do this that are sort of widely published. So people will recognize what it means to have a resolution put in front of a group of people, or what it means to amend it, and what claim is being made when groups of people say we have collectively authored this text. What I think is novel is the many, many sites in which this is happening in America. Because there is a vacuum of authority in America, predates independence. I mean, the British didn't even send a bishop to America before independence, because what bishop was going to come and live in America? Again, we're sorry. So that meant that local vestries took on an importance, organizing churches that they didn't have in Britain. Local militia companies need to organize in a way that the army does not need to organize itself in quite the same way in Britain by the late 80s. And so I think there are just many, many more sites for this kind of collective quasi-constitutional action to take place in America. And I think that's surprising. So I think the British probably underestimate, certainly the British leadership in North America, underestimate the extent to which there really has been a sort of momentum behind a declaration of independence. I think British leaders think that if they can just get the members of Congress in a room and threaten them with trial and say, look, you know, your military forces are not doing terribly well, how would a pardon sound, that those people give way. But I think, you know, one of the things that they underestimate is that there is a huge sort of momentum behind the members of Congress. How does this all go down in Britain? Well, there are some famous tracts that attack Americans for anarchy and hypocrisy and all of these other things. But I think the overwhelming thing is a phenomenon that we would recognize now, which is a lot of people saying, this thing in America proves that I was right about my local thing in British politics. And so you see, so a lot of energy in Britain. A lot of the opposition sort of are on the side of the Americans because it's a way of advancing their calls for reform in Britain as well.
Dr. Cole, this is very fun. It's always nice to be reminded of your heritage as an American. And I wonder, I noticed I had not been familiar with the Quill project before today, and I noticed that you're looking at other constitutions as well. And I would like your insight on how we compare.
So we're interested in sort of these collectively drafted constitutions. One of the reasons that I wanted to look at other, I mean, I'm an American historian, so what am I doing looking at Australia and India and other places? One of the reasons I really wanted to do that was to show just how important the American example had been in other places, that this becomes a normal way for writing constitutions. Because if you look around the world, very few countries have a federal system that is like America's federal system. I mean, you can argue a couple of cases, but that aspect of the American Constitution has not been widely copied. And that's sometimes a surprise. But the people who were drafting India's constitution in 1946 didn't just have the federal example to draw on, and they were in correspondence with people who were in the middle of redrafting state constitutional texts at the same time. So there's quite a lot of borrowing of language internationally from state constitutional texts, as well as sort of looking at the federal example, and that's been fascinating to try and chart. But you do get some interesting moments. And my favorite moment in the Indian Constituent Assembly is this. There's a moment in 1947 when there is a motion to include a due process clause in the Indian constitutional text. And there are three groups. So there's one group that says, of course we should have a due process clause. It's an ordinary element of British law, and we should definitely have it in India. There's another group that says, we should not have this. Look at what the American Supreme Court is already doing with a due process clause in that context. This will introduce a kind of uncertainty into our laws and will lead to a judicial supremacy, and we absolutely shouldn't do it. And then there's a third group that say, look at what the US Supreme Court is doing with the due process clause. We absolutely need this. And that group loses, and they don't put the clause in then. They add it in the 1970s instead. So there is a lot of interchange, but you have to go looking much deeper than the federal text. But certainly the American tradition of debating a constitution has been incredibly important internationally.
Professor, having served on a grand jury once upon a time, I have a question about that when it comes to South Carolina, because when you, at least in modern America, we have compulsory grand juries. So in contrast to some of the more voluntary assemblies that you were talking about at one point, I'm wondering if the South Carolina example shows kind of the contrary, when even if you gather random people from South Carolina and get them all together, they're kind of already also in support. And so that kind of shows a broader base in support of this?
That's definitely the theater, isn't it? Now, we could debate offline, we don't have time to do it now, exactly how random grand jury selection is in South Carolina in 1776. But I take the point, and of course that is the sort of rhetorical power of that publication.